if the court has misinterpreted you, myself, as a 1 to 4, that I never said I want to bring application. I said I'm humbly requesting this court to make submission based on my objection of the postponement. Thank you.
Advocate Baloyi.
My Lord, in the circumstances which have been fully canvassed regarding the disclosure of the second docket, the state has already indicated, my Lord, that we are not going to oppose the request of Advocate Mshololo.
Reply.
Thank you. Accused 1 to 4, Your Lordship, we are vehemently of the big interest to oppose the contemplated postponement in this matter. And we are hereby making submission as to opposition to the contemplated postponement, because it won't be in the interest of accused 1 to 4. It will not be in the interest of justice. As we say in the maxim of law, justice delayed is justice denied. Our submission in opposition are as follows. We came to realize a material defect which does not give this court a jurisdiction to hear and grant the application contemplated by Advocate Mshololo. The jurisdiction of this matter is a common cause that is under the local division South Gauteng in Johannesburg. And as we stand before this court, the procedure in terms of the Minister of Justice to give this court a jurisdiction has been grossly violated. Section 110, read with Section 111 of the CPA, they have been violated. And here, I've got...
Section what?
Section 110. Section 110 is talking about when the accused have been brought before the court that does not have a jurisdiction. Read with Section 11, treble 111, which is about the direction by the Minister of Justice to give the court that does not have initially, did not have a jurisdiction to hear a particular matter, in particular this matter of Sevilla and 4 others, State versus Sevilla and 4 others. Phosphorus CAS 636, 10/2014. And now here before this court is a Pretoria CC 67/2020. This court does not have a jurisdiction to entertain this case. It is therefore in the same spirit that the contemplated application of Advocate Mshololo is being brought at the wrong court, therefore cannot be granted by this court. And that, if it has to, accused 1 to 4, if feel aggrieved, we will have to bring the application, or we will have to bring the review or the appeal against. I know this court has not yet ruled as to that application will be granted or not. But in case it has been granted, our grounds of review or ground of appeal will be based on the fact that the wrong court has granted postponement, which inherently was not supposed to have granted. We have, there is Annex double A. It was handed before the court, Your Lordship. Can Your Lordship have that document in position? Because this is contemplated to be, it's read as follows. Direction in terms of Section 22, subsection 3 of the National Prosecuting Authority Act 32 of 1998, read with Section 111 of the Criminal Procedure Act, Act 51 of 1977. Close quote. I now read this document for record. Investigations of Phosphorus, CAS 636-10-2014. Whereas I, Shamila Batoy, National Director of Public Prosecutions of the Republic of South Africa, deem it in the interest of the administration of justice that the offense of murder, read with Section 51, subsection 1, as well as Schedule 2, Part 1 of the Criminal Law Amendment Act 105 of 1997, open quote, 1 count, close quote, allegedly committed at or near Phosphorus within the area of jurisdiction of the Director of Public Prosecutions, Gauteng Local Division of the High Court Johannesburg, and decided upon within the area of jurisdiction of the Acting Director of Public Prosecutions, Gauteng Provincial Division of the High Court, Pretoria. I therefore hereby direct that the investigations in respect of the aforementioned matter be commenced and concluded for purposes of decision making in the area of jurisdiction of the Acting Director of Public Prosecutions, Gauteng Provincial Division of the High Court, Pretoria, given under my hand at Pretoria on this 9th day of February 2020. That's the day when the burglary happened at Pala Farm. It was on Sunday. Signed by Advocate S. Batoy, National Director of Public Prosecutions, the Republic of South Africa. Close quote. I, in confidence, take this honorable court in terms of Section 110 of the Criminal Procedure Act 51 of 1977. I was still young by then. The provisions of Section 110 of the CPA 51 of 1977 reads as follows. Subsection 1. Where an accused does not plead that the court has no jurisdiction and it at any stage. Paragraph A, after accused has pleaded a plea of guilty or of not guilty, or paragraph B, where the accused has pleaded any other plea and the court has determined such plea against the accused, appears that the court in question does not have jurisdiction. The court shall, for the purposes of this act, be deemed to have jurisdiction in respect of the offences in question. Subsection 2 of Section 110, where an accused pleads that the court in question has no jurisdiction and the plea is upheld, the court shall adjourn the case to the court having jurisdiction. Close quote. This is a Section 110, where of the concern, Your Lordship, naturally, and at some stage I had my learned colleague, Advocate Mshololo, raising that we could have pleaded other way around. Should I have knew about the contents of 375? So here, that's where I'm supporting her. I mean, the Section 110 is meant that where an accused, then the court shall adjourn the case to the court of having jurisdiction. And read with the provisions of Section 111 of the CPA, 51 of 7, Section. There is a violation of the provisions of Section 111 by the DPP or minister himself. Then, subsection 1 of 111 reads as follows: where the minister deems it in the interest of the administration of justice that an offence committed within the area of jurisdiction of one Attorney General. In this regard, because we haven't changed our statute, we are now NDPP. Be tried within the area of jurisdiction of another Attorney General. He may, in writing, direct that criminal proceedings in respect of such offence be commenced in a court at a place within the area of jurisdiction of such other Attorney General. Subsection 2. Subsection 2A. The direction of the minister shall set out the name of the accused, the relevant offence, the place at which, open bracket, if known, close bracket, and the provincial division in which the offence was committed, and the place at which the relevant criminal proceedings shall commence, and the provincial division in which such place is situated. Paragraph B of subsection 2. A copy of the direction shall be served on the accused, and the original thereof shall, save as is provided in subsection 4, be handed in at the court in which the proceedings are to commence. Close. Subsection 3 of 111. The court in which the proceedings commence shall have jurisdiction to act with regard to the offence in question of such court. Subsection 4. Where the minister issues a direction under subsection 1 after an accused has already appeared in a court, the original of such direction shall be handed in at the relevant proceedings and attached to the record of the proceedings, and the court in question shall, paragraph A, where the accused is not in custody, cause the accused to be brought before it. And when the accused is before it, adjourn the proceedings to a time and date and to the court in which the accused is to appear in accordance with the said direction. Paragraph B. Forward a copy of the record of the proceedings to the court in which the accused is to appear, and that court shall receive such copy and continue with the proceedings against the accused, as if such proceedings had commenced before it. Subsection 5. The direction of the minister shall be final and not subject to appeal to any court. Close quote. That is the provisions of section 111 of the CPA, Your Lordship. Then I come back to Annexure AA. Number 1, violation of the jurisdiction. This document is purported to be the third direction by the minister. And this direction is not signed by the minister. This direction is signed by the National Director of Public Prosecutions. And furthermore, the purpose is not even centimeter next to the provision of 111. The purpose of this document, AA. Because this, it is clear, unless Advocate Baloyi can prove me otherwise. It's talking about the investigation of Phosphorus Cars 636-10-2014. And when I look at the signature, not the signature per se, but it was signed, it says, given under my hand at Pretoria on the 9th day of February 2020. And the signature is purported to be that one of Advocate Shamila Batoy, whom we know is the NDPP. And in terms of section 22, subsection 3, yes, can give the direction in terms of as to where the alleged offense can be investigated. She's got that power to investigate, not for the matter to be heard by the court. By the court is the minister. So there's no more where minister is appearing here. And then, furthermore, the revelations of this document. It was signed on the 9th of February, 2020. We checked the calendar that the 9th of February 2020 was Sunday. And the day that we believe our Honorable Shamila Batoy is off at home with their children.
9th of February, what year?
2020. If it wasn't because of Julius Malema reading the conference that the butler at Palapala was on the 9th of February 2020, I wouldn't be aware. Furthermore, Your Lordship, we are so very much doubtful that unless we can be proven otherwise, because we are doubting even the signature that purporting to be of the NDPP. Unless we can be proven wrong. And the only authority that can prove us wrong is the police investigation in terms of the document, question document. And even Ms. Batoy herself. We are of the strong view that she should be called and come in the box there and tell and confirm or corroborate this document. And another revelation or the mystery, Your Lordship, is that When this document was signed on the 9th of February 2020, these 5 accused, yeah. Five accused. And I say deliberately 5 accused because there are 5 accused. I'm just saying, in case I want to be reprimanded, that don't talk about accused number 5. But it's accused before this court. And I believe it's also before this court in the manner that if 1 to 4 are not in the manner that is proper, it applies to him. And we could not have been furnished. Let me say deliberately or reluctantly, given the reasonable reasons why this matter is before you, Your Lordship, in Pretoria. No reason at all. That's where we mooted that we would love if our Honorable Shamila Batoy can come and sit in that box and corroborate or deny. We so wish. It's our humble request that will follow and will substantiate why. So, what I'm saying, Your Lordship, when I say on the 9th of February 2020, whoever was the investigating officer in South African Police Service under 636-10-2014, this will, by extension, goes to my learned colleague on my right hand, Honorable Advocate Baloyi, George by the name. Was aware that accused were arrested. So, the first time the accused appeared before the court, it was in Boksburg on the 27th of October, 2020. As we were informed by the Honorable Minister of the Police, Mr. Kele, that during the press conference of the 26th of October 2020, the South African Police Service's breakthrough on the murder of Senzo Maiwa, the Bafana Bafana and Orlando Pirates keeper. It was 9 months before my client were arrested. How on earth, Your Lordship, with a due respect, can this purport to be the certificate of giving you the inheritance of this matter? How on earth can you assume, can this honorable court assume the jurisdiction pre-hearing? Yes. So there was somebody, I don't know if Honorable Advocate Batoy is a practicing gogo, the Sangoma. 9 months can contemplate that this matter will be here. What about the minister? It's not for Advocate Batoy. As we've just went through the provisions of Treble 1, that the directions and the jurisdiction will only be given to particular court. I mean, the jurisdiction will be given to a particular court by the Minister of Justice, provided it is in the interest of administration of justice. So now, not Shamla Bato, as I said, she can only say, all right, the police, together with my deputy director, or together with my senior prosecutor, maybe in this case we talk about my learned colleague, Advocate Baloi. Let's agree that the matter be investigated under the DPP Mzinyati in Pretoria. So, and then it's been taken from the DPP, Mr. Chauke, in Johannesburg. So, in essence, we can consider this annexure AA to be internal communication in the NPA. It's not a direction by the minister to give it this court a jurisdiction. My learned colleague will reply and can also prove us wrong or give us the relevant documentation, because it was his submission before this court that this is indication that this court can inherit or can entertain this matter. Which this was preached 9 months before our client were arrested, as I said. So, Your Lordship, therefore, we submit that SRQs 1 to 4, whichever is the contemplated application before this court, and whatever has happened before this court in terms of Sergeant Musia giving the evidence in chief, and I cross-examined him, and my learned colleague, Advocate Msololo, cross-examined him, and she is still of desire that she must continue cross-examine Musia in terms of the contents of Phosphorus Cast 375-01-2019, for which, Your Lordship, that content of that docket, which is not before this court, they've got nothing to do with Musia. And now it doesn't matter. It doesn't matter whether my learned colleague, Advocate Mushololo, is still having that aspiration or desire to continue the cross-examination of Musia, because it doesn't matter anymore. What we had, what she had, It's a brick bundle, she's saying that. Whatever we had, we had. It doesn't matter. And it is in this spirit, Your Lordship, and I would love to say thank you very much for affording me this opportunity to support the opposition of the postponement requested by my learned colleague, Advocate Mushololo. And last but not least, which is very of importance, because if indeed it will be found that this court does not have a jurisdiction, the game will change. Of the West, we will consider that our client have been kidnapped from Johannesburg to be brought here and tried against their will before this court. And we will deny that our client be prosecuted by the court that does not have a jurisdiction. However, because the court is the court, it's got the power, can make a ruling. If this court make a ruling that no, despite the fact that you see what you are reading, then it will lead us somewhere. However, I now, as I say, these proceedings before this court, as contemplated by the provision of section 111 of CPA, saying only if it's in the interest of administration of justice, the minister can afford a particular court a jurisdiction. But whereby the minister didn't afford that court such a jurisdiction, and we have the client here. In my case, I've represented accused 1 to 4. Accused 1 and 2, when they were arrested outside. They were not serving any sentence in any court. I've got accused 3 and 4 who were serving sentence, and they were in the process. When they were alleged of this Maiwa matter, they were in the process of appealing the conviction and the sentence of those matters. Accused number 3 was in Johannesburg prison, and accused number 4 was in Leeuwkop. But I stand to be corrected. May I approach accused number 4?
Yes.
Thanks for indulgence, Your Lordship. Well, I was right. Accused number 4, the J7 was signed by that honorable court that gave him the sentence to go and serve at Leeuwkop, which is a jurisdiction of Johannesburg. And I was also correct with the accused number 3. The J7 was signed by that honorable court giving the sentence to serve at Johannesburg prison. And 1 and 2 were just arrested outside. So, if the procedure has to be followed in this regard.
So, according to you, the implications of them having been arrested when they were outside, what are those implications?
1 and 2?
Yes.
Yes. The implication is that, as per the provisions of section 110, that says, if the accused insists that we are at the wrong court, then from here, the court has to adjourn, and because this court does not have a jurisdiction, this court today cannot say to them, you are remanded in custody. They just leave, they go home from here. Yes.
Okay.
It cannot be this court saying, you are in custody.
So if a person is outside when they are arrested, when they appear in court, they should be told to go home.
Let me say this. The court, somewhere in Boksburg,
Yes.
that sent them to court. That sent them to prison. Because one is now in Modabin Binoni. And then one...
No, you are not replying.
No, I want to study there because it's a history. I want to say
But whatever you say by way of history, my question will still be one at the end of the whole story.
Okay.
You are saying whoever is arrested while they are outside, when they appear, the day they appear in court, they should be told to go home.
What I wanted to say before Your Lordship interject, I wanted to say the court somewhere, the court that signed J7 for them to go to prison, well, they were naturally not in prison, not serving any sentence. It was misled by the Honorable Advocate Baloyi. That court was misled. And at no stage, there was even an attempt. Actually, 1 and 2, they've been in custody without a trial. Because we did consult. At no stage, there was never any attempt after they were arrested, so-called arrested in June. They were never taken to any court. Within 48 hours to apply for a bail, and they be given a bail if it is in the best interest of justice. So their situation was like that of pre-1994, apartheid system, whereby there will be detention without a trial. That's what they have suffered up to today.
Yeah, I don't want to enter into an argument with you about without trial, because I thought we are in a trial.
Before the 22nd of April, Your Lordship. And then to further make submission as to what are the consequences, Your Lordship, I say further that the implications is that as at one stage I made an attempt previously in terms of the special plea. The implication is that accused 1 and 2 are unlawfully arrested, and that is in violation of their constitutional rights. In terms of Section 35.
Unlawfully arrested or detained, or both?
Unlawfully. They are unlawfully arrested and unlawfully in detention. And that was unlawful after 48 hours somewhere in June 2020. After 48 hours, they were still kept at the police stations, various police stations. So that arrest after 48 hours became unlawful arrest and detention, which persisted until the 22nd of April when they pleaded not guilty. So I shudder to think about the consequences of postponement to September. Let alone September. Even if it could be said, Your Lordship, that we postpone overnight, the violation of their constitutional rights in terms of unlawful arrest and detention is continuation. Because, like I said, that is that perpetual detention without a trial. Yes, Your Lordship said, yeah, we are just giving the benefit of doubt, now they are on trial, but they are late anyway. It doesn't matter now whether we are in trial or not. And that matters making it worse is that when they believe to be before the court that should not have inherited the jurisdiction to try them. we may not disagree. In case we may not disagree, or in case this honorable court, despite the reason I've mentioned, we say no. The contemplated postponement by Mshololo should continue. We will humbly then, if it's like that, court would have said, the court has spoken. However, we'll follow the right procedure. And as long as we might have said, and it will be humble request that those people in terms of provisions of 110 and read with treble one, they have to be asked to go home as contemplated, and the court seek for the right and the parties negotiate if that is in the interest of justice, administration of justice, which court is the relevant court. And is the reason today, Your Lordship, in closure. We are in a catch-22 situation of two dockets. So, therefore, I say, these accused are before this court in terms of 636, not 375. 375, as it has been said, it will inherit the jurisdiction in Johannesburg, where we are of the strong conviction that the suspected people contemplated in Exhibit C are the one who is supposed to be before the court, and our client should be vindicated. More so, and I need Advocate Baloy to listen carefully to this point, which is very, very, very important. More so, when they were arrested, First Laura's case 636 10 2014. At the time of their arrest, it was quashed. What does quash mean? That docket was dormant. It was quashed after unlawful arrest of one Mr. Zama Kutlembat. Nonetheless, there has been another attempt now. This time, as if it was not enough to arrest one person, Zama Kutlembat, the state said, no, we need 5. Zama Kutlembat alone was not enough. So, it is in a relevant authority, Your Lordship, that Docket 636, when the accused were arrested, it was quashed because of unlawful arrest, the first unlawful arrest. Therefore, insofar as the conundrum of 2 dockets is concerned, Your Lordship, and as I've indicated that Exhibit C and D were brought before this honorable court by accused 1 to 4 in order to indicate that there is a relevant docket that must be entertained, but not by this court, but another court, which is in the south. This is our submission, Your Lordship, and then we'll hear from the Honorable State. Thank you.
This morning, Advocate, therefore, in my view, was in an attempt to bulldoze his way, procedure-wise, in as far as these proceedings are concerned. The court would have none of that, and I'll address it briefly. And the court did not go the route. Advocate therefore was forcing it to go for reasons that I shall explain. In due time, when his time came, Advocate therefore has addressed this court at length, an opportunity which was always at his disposal all the time when he was trying to bulldoze this court into a procedure which comes foreign to it. He mentions aspect of ethics, and my view is very dim in terms of his adherence to ethics. In court, what obtains is that if you present something and the court overrules you, that is the end of the matter, albeit a temporary end, because if injustice is brought to bear due to being overruled, it becomes a matter or a point for later on review or on appeal. But what is surprising, and it continues to surprise me, is that whenever Advocate therefore is overruled on any matter whatsoever, if you succeed after a long struggle to get him not to proceed, the next time you proceed, you give him an opportunity to address something else, however unrelated. He will go back to an issue on which the court has already given a ruling. Yet he purports to be a proponent of ethics. There are issues, and I think he would be entitled to raise them, where he feels that before I go there, he harps on the issue of respect. And respect is when, or disrespect to him is when, after being warned and overruled by court several times, he insists on proceeding on the same issue about which the court has already given a ruling. And if you don't grant him his way, then you are not respecting him. And I don't know what that says about his respect for the rule. The court is well vulnerable to erring in any ruling. I do not think the court should think of itself as a whiz kid on any matter. It will err from time to time. And in our system, there's a way of dealing with instances where the court errs instead of adopting a no masafa attitude. We note where the court brought injustice to bear by way of ruling wrongly, and we deal with it according to the law. And that is the measure in place to ensure decorum in our courts of law. And I want to repeat, I am subject to erring Whoever will go and look at my work will find that other courts have corrected me from time to time, as will happen with any judicial officer. The aspect which was tricky is that Advocate Mshololo is on the forum presenting a matter towards a particular direction, something that started in the absence of Advocate Tefo. And when he comes, his approach is as if Advocate Mshololo is not on the podium presenting a matter. And that is where we found our differences, and that is where he found cause to accuse the court of disrespect. And he is right to say he cannot be expected to rubber stamp. And he claims that he is not bringing his own rules. But I must say that I am yet to read the rules Advocate Tefo operates upon. And that is what gives me the jitters if I were to apply them the way he wants me from time to time to apply those rules. And I keep on saying the rules for court processes are written down in black and white. And court etiquette and court practice has ordained that in court a party will present a matter or an application, the counterparts will be given an opportunity in their turn to respond to what has been presented. And when they have done so, as happened this afternoon after a long struggle with Advocate Tefo, the person who rose with the matter will be given an opportunity to reply. And in the reply, Advocate Tefo brings issues that were not on the table of his counterparts, Advocate Mshololo and Advocate Baloyi. Partly he blames the court for having not given him the opportunity to bring those issues on the table. Maybe that is an argument for another day. However, whichever way you look at the presentation and the responses, some new issues, I don't know whether new is the word, but some issues for consideration have landed on the table of this court, which go to suggest that this matter is wrongly before this court. As I sit here, I have my views, but I'm not a party. I think it will be best to grant the opportunity to the parties concerned to respond to some pertinent issues before we proceed with this matter. Before I name those aspects, Advocate Mshololo, like any other defense counsel, wants time to go about preparation of the defense of her client. a right which should be available at her disposal and her client's disposal by virtue of the reading of the Constitution of this country. And therefore, the court, I think it has been mentioned that if the court does not rule the way Advocate therefore prefers, then it should ready itself up for something coming by way of a review or whatever other legal process. Looking at the scenario, I have been told as I sat here that there's a day way in the past when Advocate therefore was favored with a copy of the so-called second docket. It is therefore understandable that Advocate therefore is at home with issues from the second docket. That is why he was able to articulate on some of them this afternoon. But that is not the case for Advocate Mshololo. It is not the case for Advocate Baloyi, who both claim that this docket, which Advocate therefore had all the time, was given to them at a later stage. The case for Advocate Baloyi may be questionable, as Advocate therefore raised it, but there is no denying that Advocate Mshololo was not favored with a copy of the second docket at an appropriate time. And this is what is bringing the delays we are experiencing. And in respect of the rights of accused number 5, the court will be very inclined to a reasonable or to a postponement over a reasonable period of time. Whilst Advocate Mshololo goes over what has been recently discovered to her, and whilst she considers her options, of which she has already mentioned that it may include further consultation with her client, and where she also mentioned that she cannot rule out a particular application coming the way of this courtroom. The court has identified certain aspects that have to be put into perspective. And having said that, it may require that all that Advocate therefore was mentioning before court this afternoon be reduced into heads, to which everybody concerned shall respond, so that in between the time Advocate Mshololo will be going the route she has mooted, something unfolds that brings clarity and a way forward regarding the aspects I'm about to mention. And it may well be more of a baby for the purposes of Advocate Baloyi. The first point is that the minister did not sign. Like I said, I have my views, but I'm not a party. The minister did not sign the relevant document. The DPP, in the person of Advocate Shamila Batoyi, signed. We may require a pointed response to that aspect. Secondly, that even if Advocate Shamila Batoi signed a relevant document, its reading suggests that she signed on a Sunday, where she was supposed to have to be home and not in an office. Like I said, I have my own view. I have signed documents on any day of the week, but I'm not a party. Thirdly, accused number 1 and 2 were outside when they were arrested. I tried to pursue this with advocate. Therefore, I didn't get a pointed answer, but I have come to perceive his reasoning to be that in this case, because they were outside when they were arrested, after their first court appearance, they should have been allowed to go home. Alternatively, because he doesn't put it in so many words, alternatively, that advocate therefore has issues with the fact that after the initial arrest, accused number 1 and 2 were not made to appear before a court of law within the ordained period of time, which is 48 hours. And thirdly, which points to Advocate Baloyi, that when accused number 1 and 2 appeared for the first time before court and where their case was postponed with them in custody, that happened because Advocate Baloyi misled the court. I had questions on this one, which I decided not to ask because it would border towards me making myself a party on these matters. These are the issues that came through as more pointed among others, as advocate therefore addressed court. And my suggestion is that we find a way of addressing them. Whilst we have had Advocate Mshololo indicating that she needs time to do 1, 2, 3, which I will not repeat, it will be wise of us to deal with these issues, whether it includes calling people before court that are not here or having their affidavits, but that should all be captured in heads that the court shall study and make a ruling. And something pleased me this afternoon, where for the first time in some bit of long time, I had Advocate therefore saying, were the court to rule out of or to rule not in tandem with his aspirations, he contemplates or reserves his right to launch a further legal process. And that is how lawyers respond to anything that courts rightly or wrongly pronounce. So, because we had a date about what Advocate Mshololo had or thought of doing, I think we should have a nearer date in order to address this. I must be well understood. I'm not ordering anybody to do or to come to court who feels that they are not supposed to be before court. All I need is for these issues to be addressed, whether by way of getting some people to come who are not here, or by way of submitting affidavits that will bring the court up to speed regarding the issues raised. My strong view is that the terrain is not all that flat to just blindly proceed with this matter, with these serious issues. Lest I find myself with serious egg on face at a later stage with these issues having been raised. For now, these issues may or may not be founded, but it is better to arrive at a decision rather than to land there without consciously deciding. Because for me, it determines whether we are on the correct train in terms of proceedings in this case. And it brings to mind a quotation by Bonhoeffer, which says, once you board a train, once you board the wrong train, it doesn't matter how fast you run to the opposite direction. That train will still take you to where it is going. So for that, I would that we find a date where Advocate Baloyi thinks he will be ready with these issues, because I presumed that the manner these issues came out, it may be that Advocate Mshololo and Advocate Baloyi are not prepared for all the issues that were raised. But if they were, my issue is that they reduce their responses into heads.
As a court, please, my lord, can I make a suggestion?
Yes.
Would it not have been perhaps better for Advocate Tifol to bring a substantive application and then reducing his arguments to writing,
Yeah.
and we can agree on a timetable, then we can respond to that. Because one of the issues that he raises, the reasons why jurisdiction was transferred, and one is not always sure as to exactly what are all those issues. So at least if they are in a written form, we can then address those issues pertinently, my lord.
Yeah, well, it is exactly why I myself cannot rule towards any direction after his presentation, because it did not come clear, which I think will not be the case if it were to be captured into heads.
Yes.
It is again why I am saying that we should have heads, so that we have something formal,
Yes.
to which all can respond formally,
Yes, indeed, my lord.
and about which court can pronounce formally.
Yes, and about which there will be no doubt, as
Yes.
unlike it is at the moment.
Yes.
Your Lordship. Sorry. I again trying to demote you, Your Lordship. I'm amenable to, but I'm just only opponent of substantial, because I've learned to know and understand when Advocate Baloyi says substantial, there is something that is launching for. Something will be brought here relevantly so, and then the so-called substantial, because substantial is sublinear to me. It's like, as I know him, that is a font of guerrilla warfare style to ambush. I'm unable to bring submission in writing as per instruction, and then on that issue
Are you not launching an application?
Pardon?
Is this not an application on your part?
No, I was just responding to him.
Yeah,
This-
I'm saying, if it is an application,
Yes.
there's only one way of launching an application. It has to be substantial to be entertained.
Yeah.
About the booby traps Advocate Baloy is capable of.
Yeah.
You are a soldier, you'll see how to diffuse
Yeah.
those booby traps. We cannot forsake a known procedure just because we are afraid of booby traps.
Yeah, I would just like to remind the Honorable Court that he's just not coming to me, like I'm just me. No resources. Remember, you come with the state resources. So that's what is very important for the court to be aware of. However, I'm saying that in terms of what the court mentioned, in case I heard the Honorable Court says, if there would be the people that had to come here, or the affidavit. We are dealing with the criminal proceedings here, Your Lordship. So if there will be any affidavit, it has to be followed by the author. Because I don't think we will, I just wish and I just pray that somebody should not depose an affidavit and thereafter the person become permanently absent on earth, whereby we will have to go and try to bring the application in terms of the provisions of Section 3 of the Law of Evidence Amendment Act. So it's a natural that once there is an affidavit, then it has to be come and corroborated by the author. Like I said, unless the natural volition has taken its place, someone is absent forever. So, and then I do understand give him the benefit of doubt, this predicament, it will be supported or substantially be brought as per the instruction. As it please the court, Your Lordship. Okay, and further to that, there was overlooking or oversight, but was not deliberately on the side of the court, that insofar as the accused are concerned, 1 and 2, because it will be injustice if we have to agree on the date for which is a procedural, say, on this date, the court will put us in tender, hold us in terms to say the counsel for accused 1 to 4, bring your substantive application on this date and serve the state, serve Mushololo, and then if there is a reply or answering, because those will be the allegations. And the Learned Court will teach me here, because I'm still very much learning, Your Lordship. We depend on you for the guidance, because you have seen a lot of things before we see them. You're a father, you're a grandpa. Insofar as holding us in terms, say from today, in 3 days, defense for 1 to 4, bring your substantial application in relation to the jurisdiction. And then, in 48 hours or in 2 days, advocate the state, answer those allegations. And then, when I say I need a guidance from this honorable court, I don't know what to say to Advocate Mushololo, because she's my fellow defense. And it seems as if now the defense is not united. And as you can know, Your Lordship, that...
Yeah, let me request you to address me. Leave her alone. She's running, she's...
Parallel.
Yeah, no. You told us this afternoon that you are afraid that your clients will unemploy you.
Okay, yes.
Yeah. Now, don't push her to be unemployed by a client. Let her independently run the defense of her client.
Thank you, Lordship. So the guidance that in between or in the meantime, yes, I'm of the support of the expeditious hearing of this matter as it is material, where it will put my client, accused 1, 2, 3. Why accused 1, 2, 3? Accused 1, 2, 3, as I said, that if there is any postponement today, as we postpone, obviously we are not going to sleep here. And I don't foresee that I will get the answer today.
Yeah.
What will put
Maybe
my
I should
client-
give you a quick answer to that one.
Yes.
Similar to an answer I've already given you in some other unrelated issue in this very trial. In our legal system, one of the things we do is to apply the rules of natural justice.
Yes.
And one or a rule of natural justice that is relevant, that comes to point here as you are saying what you are saying, is that is one that says Audi.
Partam.
I don't know whether it's called what you are saying, but in English it goes here the other side.
Yes.
Yeah. And now, I do not think your clients woke up one day and decided to walk to a prison. Somebody took them to a prison or into incarceration. And
I agree.
You are now saying they should be allowed to go home before we hear from the person who put them where they are. And the court is not likely to do that, simply because it has to respect that rule of natural justice. In the process that you are demanding, the process, the pace of which you demand should be a fast one. I think that rule will be accommodated, because I don't think we will have a situation where people are arrested and they go to court. Somebody who did not arrest them but is merely assigned to hear their case decides that they are going home. There might be some things we don't know. I don't know. So I will be more comfortable if I hear from the courts that ensured that they be incarcerated.
Yes, but I know.
Yeah, I don't know.
Yes, I agree.
Yeah. The difference between me and you is that I don't know, and until they come, I don't know.
No, this is reasonable, Lordship. So the process can be that one of expeditious in terms of agreeing intent.
Advocate Mshololo and Advocate Baloyi, I agree full square with Advocate, therefore, that for this aside issue, we really need maximum speed, lest we continue to undermine the rights of I would agree with him and say of everyone, including your client. So, but I wouldn't put it in terms that he put it, that he gave himself more time. And when you have to address those many issues that he was addressing about, he gave you 48 hours. I think I wouldn't go along with that. But I think reasonably we should be at a fast pace in dealing with this matter.
I think, my Lord, that can be arranged amongst the councils,
Yes.
regarding the time frames for the exchange of the documents,
Yeah.
as the court pleases.
Advocate Baloyi?
Indeed, we are agreeable to a timetable for the exchange of papers. The only question, my Lord, that remains is the date to which the case must then be postponed.
Yeah, I'm saying because it's you determine. This is a criminal matter. In criminal matters, we are used to having the accused before court when we deal with those cases. And it would seem much as it won't assist the process we are talking about. I don't see any reason for not requiring them to appear when issues will be, especially when we are also touching on issues of
Jurisdiction.
of jurisdiction and issues of incarceration,
Yes.
or being let out. But I do not think for the immediate foreseeable future when there shall be submission, I don't think we need them here, and I don't even think we need you here. I would think that there will be an interaction between the parties regarding the heads, and when those heads are argued, that is when we will determine that they be before court. And that is why I asked what would be the most immediate date we gather here for this matter. I would even go as far as to say that for that purpose, I would importune all of you to even venture into recess time, so that we find a day to deal with those heads, which will then give me an opportunity to find time to come up with a response to the submissions you will have made.
Yeah, as the court pleases, my lord, I think that would mean we still need to consult with the role planners. One cannot just postpone a case without their consultation, because, I suppose the JP also, seeing that this is a partly head matter, there also has got to be a consultation with the.
We are way over our time, and as for the one going to Kosimampuru, you may even say now that person will not have supper, which is unfair.
Yes.
Should we not postpone overnight and deal with that aspect? Consult the role planner and everything, so that we come with an informed view tomorrow.
That's in order with us.
Advocate, therefore, you are excluding yourself.
Tomorrow.
No. I'm saying, I asked the question, the rest have given an answer, you didn't. I say
Yes.
you are excluding yourself.
We postponed this matter overnight.
Yes.
That's correct. Court please insert.
Okay.
Yes.
Please rise.